Good morning. Our next case is State versus Kelliher, and we'll hear from the appellant.
Good morning, Your Honors. May it please the court, my name is Heidi Williams. I'm here from the North Carolina Department of Justice. I represent the state as the appellant in this case. I would like to request 7 minutes for rebuttal. In 2001, defendant participated in the robbery and killing of two 19-year-olds and their unborn child. And for these murders, he was sentenced to consecutive terms of life imprisonment with the possibility of parole. In 2022, however, this court held that the consecutive nature of defendants' life sentences rendered them unconstitutional and therefore remanded the case for resentencing, directing the trial court at that resentencing to impose concurrent rather than consecutive life sentences for defendants' convictions of first-degree murder. On remand, the trial court complied with this court's directive and imposed concurrent life with parole sentences for defendants' murder convictions. Then, relying on the statutory authority of NCGS 15A-1354A and this court's recent opinion in State v. Oglesby, the trial court chose to run defendant's remaining term of years sentences for his convictions of armed robbery, which were imposed at the same time as the life sentences at his original sentencing hearing, consecutive to defendant's mandated concurrent life sentences. By acting thus, the trial court here both complied with this court's directions in its 2022 opinion in Kelliher and acted within the scope of its default statutory authority under NCGS 15A-1354A. The state therefore respectfully asks this court to reverse the decision of the Court of Appeals and to reinstate the trial court's 31 March 2023 sentencing order. I invite questions from the court at any time. This case at base deals with the proper application of this court's opinion in State v. Oglesby and the proper interpretation of NCGS 15A-1354. In State v. Oglesby in 2022, which was after this court had remanded this case for resentencing in the first round of appeals, this court explained that under NCGS 15A-1354A, a resentencing court possesses authority to run any and all of a defendant's sentences imposed at the same time as his original sentence, either concurrently or consecutively. The defense has raised several arguments suggesting why Oglesby either doesn't apply or is distinguishable from the circumstances here. One of those differences is that in Oglesby, the defendant had requested that the court address his term of years sentences, and here in his original motion for appropriate relief, the defendant did not specifically ask the court to address at the Miller resentencing hearing those term of years sentences. However, in Oglesby, this court addressed the proper interpretation of 15A-1354A, and nothing in the language of the statute predicates a trial court's authority to run sentences either consecutively or concurrently on the defendant making the request that the court do so. The defendant raised in support of that argument that the trial courts did not, in fact, have authority to revisit those term of year sentences because he did not ask the court to review those term of year sentences. In his appellee brief before this court, the defendant cited both Williams v. State and State v. Case. Williams v. State was a 1968 Court of Appeals opinion, and State v. Case was an opinion from this court that was issued in 1966. Importantly, both of those opinions were decided before the legislature enacted 15A-1354A. That statute was enacted in 1977. In addition, both of those cases cited by a defendant dealt with circumstances where a trial court granted, or where an appellate court, granted a retrial. So the cases there, the defendants had not asked to be retried. They had asked for other forms of relief. The courts then ordered retrial, and because the defendants had not asked for that relief, the courts in both Williams v. State and State v. Case said that retrial could not be required in those circumstances, but it was predicated on double jeopardy principles. Here, we're simply dealing with sentencing questions. So none of the defendant's underlying convictions of first-degree murder, of armed robbery, of conspiracy have been disturbed at any point in time in the appellate process. Instead, this only deals with the scope of the trial court's sentencing authority at resentencing. The state has asked this court to, in interpreting the scope of its mandate, to expressly adopt a presumption in favor of de novo resentencing. This court, in several opinions in the past, has stated that on resentencing, we presume that we're dealing with a de novo proceeding, but has never expressly adopted that presumption in the context of interpreting an appellate court's mandate remanding a criminal case for correction of sentencing error. And I think that's important here because the presumption underlying what the trial court's responsibilities were on remand is we kind of have to understand what default they were operating from in determining to what extent this court limited their discretion and its mandate in the 2022 Kelliher 2 opinion. So the state and the defendant here both agree that the trial court at resentencing here had no authority whatsoever to alter to determine sentence for the first-degree murder convictions. Those were off the books based on this court's opinion. The court had to run those concurrently, they had to be stacked, and that was the end of it. However, this court's opinion was silenced as to what the trial court could or could not do regarding the remaining term of years sentences that defendant had incurred as part of this criminal episode. Under a presumption of de novo resentencing, this court should presume that in the absence of express language divesting the court of its default statutory authority, that authority remained with the trial court. And here, the trial court exercised that authority appropriately under NCGS 15A1354A and had the right to choose whether or not to alter those term of years sentences and imposing them up to the mandated sentences of concurrent life with parole.
So can you tell me if I'm articulating correctly how you see the statute and the mandate rule doctrine that we have sort of interacting, which is, so in normal, I mean, this most typically comes up in civil cases, like say family law cases where an appellate court might say it's remanded for the trial court to conduct a hearing on whether it's in the best interest of the child and so on and so forth. And the theory of the mandate rule would be the only thing that the court can do on remand, the trial court, is conduct that hearing, make that determination, and then anything that naturally flows from that, and anything else would be a violation of the mandate rule. But as I understand, your argument is the General Assembly, through the statute, sort of said the default when these things go back is the trial court has this power. So sort of fitting that into the mandate rule, this court would, if we were overriding that, would say something expressly like, you may only do this and this, and if we don't, then the sort of default of the law is, well, then when it goes back, the mandate rule is broader because there's a statute. Is that basically? That's
completely accurate, Justice Steeves. That's the state's position here, is how those two things interact. If this court or any appellate court wants to remove any kind of that statutory default presumption of de novo resentencing on remand for correction of sentencing error, it has to do so using some kind of express language. It has to address the question. It can't just, we can't infer from silence that the trial court has been, its default authority has been removed. Unless the court has any other questions, I would be happy to reserve the remainder of my time for rebuttal.
Thank you, counsel. We'll hear from the appellee.
Thank you. Good morning. May it please the court. I'm Catherine Vandenberg with the appellate defender, excuse me, representing James Kelliher. The panel below decided this case only on the basis of the language in the mandate. It correctly found that the mandate's language was abundantly clear. It found the mandate instructed the trial court to take one specific action, and it stated the trial court had no discretion and was not to conduct resentencing. The mandate language itself begins with, we would ordinarily leave resentencing to the trial court's discretion, but we agree with the Court of Appeals, et cetera, that they can't do anything else. And the last sentence is, accordingly, we remand to the trial court with instructions to enter 2 concurrent sentences of life without parole. The Court of Appeals found that abundantly clear. If there's any remaining question beyond the language of the mandate itself, we can look at the dissenting opinion in the 2022 Kelliher case. Obviously, the dissent was disagreeing with what the majority did, but if you look at footnote 10 in the dissent of that opinion, the dissenting court said the majority is usurping the role of the trial court by resentencing defendant in the first instance. In doing so, the majority mandates that defendant become eligible for parole after serving only 25 years. You can read the full footnote, but in short, the note shows clearly that the dissent also understood that this mandate, directed imposition of 1 final sentence, did not allow resentencing or any other additional remedy that the trial court might want to create.
So what about your argument in front of the state's making that this came up in an earlier argument, that we presume courts know the law, which includes the assumption that we know the law. So at the time that we entered the opinion in this case, initially, we were aware of the statute. And knowing the parameters, you would anticipate that we would see something in there addressing the other charges and saying you also can't resentence or change from concurrent to consecutive on those. So what's your response to that?
Well, I think this court was aware of all those other sentences. They were discussed at length, or not at length, but they were discussed. They were in the record. If the court wanted to invite resentencing, it could have said, we remand for resentencing. That's what normally happens. And I don't think that the remand is silent because it says expressly, we do not remand for resentencing. We would ordinarily do that, but we're not doing that. So I don't see a silence as to the other offenses. If you're going to, surely you don't want your mandates to have to list all the things that someone can't do. And that's a sort of a ridiculous burden. And also it invites, what if there's only 5 things on the list and someone thinks up a 6th thing? Then, the question comes back around. I think between the mandate language and the language of the dissent, stating so clearly that everybody knows what's happening here, there's one particular sentence, he has to get it. No resentencing hearing is to be held. If there's no resentencing hearing, 15A 1354 doesn't apply because that's a statute that's about sentencing or resentencing. So I don't see any authority arising from a sentencing statute. All that says is when a judge is resentencing, the judge can decide how to run the sentences. But here, we're not resentencing.
I'm sorry. Go ahead.
Well, I'll go first.
Okay.
My question is there a sense in which, I don't know that I would call it jurisdictional, but if in 2022, the court was only addressing an issue with regard to the life without parole sentences, would they really have jurisdiction to say, and you need to, because the error is not one that impacted or related to the other charges. So how would we have the power to say, unless we find some error with regard to those other the convictions for those other offenses, how do we have the authority to require resentencing on those?
Well, that, Justice Earls, begs the question of how did the court on remand have the authority to touch those other sentences? Nobody had the authority to touch those other sentences. They were never before the court in the original MAR. The sentences that were in the pleadings were life with parole. No, life without parole he had. That was the MAR filed in 2013. After Miller, came down and all the law shook out, there was a resentencing hearing in front of Judge Fox, at which the only sentences in question were the 2 life sentences. It's a law of the case issue. What did the pleadings say? What did the court then have authority to do? What did the appellate courts have authority to do? And the very last step was supposed to be, fix this problem in this exact way. And there was no jurisdiction to open up the robbery judgments, which were never challenged in a court. So that's my view of how jurisdiction fits in.
What about, I think your friend for the state's arguing, this is what I'm trying to figure out, is that everything you just said would be true, except that the General Assembly has changed those rules and said when you go back and when you're sentencing, even if you're just doing, resentencing or a court-ordered change of a sentence for one charge, the ability to move around what's concurrent and consecutive for the court exists unless we say it doesn't. What's the response to that?
I disagree with that. I've never heard of default statutory authority. It doesn't even touch jurisdiction in the first place. And this was not remanded for resentencing. If it was remanded for resentencing, 15A 1354 may have applied, although I still would contend that the robbery judgments weren't available for resentencing. Another side point to that is that the robbery judgments were consolidated into one judgment, and the trial court here vacated that original judgment. He didn't just run these at the expiration of that, but took them apart and ran them consecutively, and there was simply no jurisdiction for the trial court to have touched those.
So I'm not sure that I read the mandate the same way you do. If I understood you correctly, you read it to say there's no resentencing, but what the court said was, although we would ordinarily leave resentencing to the trial court's discretion, then the court goes on to say, here, tell the trial court it's got to enter 2 concurrent sentences for life without parole. So I don't read that to say there's no resentencing. I read that to say there's resentencing, but we're going to essentially cabin the discretion of the trial court with respect to the life sentences with parole.
I think there's a difference between, they ordered a new sentence to be imposed, or actually they ordered the judgments to be revisited, but that's different than a resentencing hearing, which is a de novo proceeding. To me, that's the distinction. And
so I think I would agree with you if it said, although we would ordinarily remand for resentencing instead here, but that's not what we said. It says we would leave resentencing to the trial court's discretion. And then there's a limitation placed on that discretion. That's what's wrong with how I'm reading that, because that seems to me to be what it says.
I think although we would ordinarily do something, suggests that we are not doing that. That's just plain language to me. I'm not quite following your question.
So I agree with you. So, but it's the although we would ordinarily X. What's the X? You're saying the X is remand for resentencing, but that's not what the X is. The X is leave resentencing to the trial court's discretion. So
I'm not sure I see the difference.
Well, the difference is, in the first case, you'd be right. There's no resentencing. But in the second case, there is resentencing. It's just what we're not doing that we ordinarily would do is leave it all to the trial court's discretion.
Well, and where I would point you there is to that language in the footnote of the dissent, which said very clearly, we don't like this, but this is what this court is doing. This court is issuing a sentencing order and not allowing the lower court to come up with its own remedy.
But of course, what we're bound by is what the majority said, not what the dissent said.
Well, that's further evidence of what the intent of the words were, if you're stuck on the word resentencing. Our mandate cases use strong language about what would happen if mandates are not enforced. Litigation would never be ended. Every court would be a law unto itself. Appellate courts would be shorn of their authority. Lower courts have to follow higher courts. The lines of authority keep order, make sure the court system is working efficiently. Our appellate courts have routinely shut down lower courts that ignore mandates and create their own remedies. It's happened in criminal sentencing cases. It's happened in civil cases where the lower court invents new injunctive relief or revisits the damages. And preventing this kind of unauthorized action requires consistent enforcement from higher courts. Mandates also matter because we need finality. Mr. Kelliher's MAR was filed in 2013. This court's prior opinion in this case came out almost 3 years ago. This is my fourth oral argument in this case. We're all still here talking about the case now because the trial court chose not to follow the clear direction in the mandate and instead made up its own remedy. I'm asking the court to make clear that ignoring its mandates is unacceptable. I'm happy to answer any other questions at this point.
Well, I do just want to ask you about the significance of the fact that the underlying sentences had already expired at the time of resentencing.
I mean, that's more evidence that there was no jurisdiction to open them back up. I know that in Oglesby, which the state has talked about, the rule that came down there was that when you're resentencing, the judge can look at sentences imposed at the same time. And the court in Oglesby talked about that being available in that case. The difference in that case is all those sentences were in the original pleadings. They were discussed at the lower court level. They were discussed on appeal, and they were part then of the resentencing hearing. In this case, none of that happened. The state could have brought it up. I mean, 15A 1354 has existed for 20, 30, 40 years. They could have brought it up like they did in Oglesby and discussed it then. They could have brought it up on appeal. They could have cross-appealed. They could have done other things. But instead, it came up after the case was finished. And then suddenly there was this new idea, you know, maybe we should go and take these other judgments that aren't part of this case and restructure the sentencing and take them apart. I think the trial court did that because it was unhappy with, in fact, the trial court said that. I don't agree with this court's opinion. I want to do something different. That goes against finality, that goes against efficient courts, that goes against waiver, that goes against law of the case. It goes against the clear mandate language that exists in this case. I would ask this court to affirm or simply rule that the state's petition was improvidently allowed. Thank you.
Thank you, counsel. Rebuttal.
Thank you, Your Honors. I want to address first opposing counsel's contention that resentencing was not what was required here. I think there are several reasons this court should reject that position. The first being that this court has recognized on numerous occasions, the state cited in its brief, both State versus Young and State versus Seam, that the appropriate remedy when a juvenile homicide offender sentence is deemed unconstitutional under Miller, the appropriate remedy is for resentencing. And so that, based on this court's precedent, should be considered the default remedy in these kinds of situations. In addition, I think when interpreting the scope of this court's mandate, we also need to, we can also look back to the Court of Appeals opinion, because Kelliher, to the 2022 opinion here, affirmed and modified the Court of Appeals opinion. So in the Court of Appeals opinion in Kelliher, the court explicitly said we reverse and remand for resentencing in the first paragraph of the opinion. And then at the end of the opinion gave the instructions, although we would ordinarily leave resentencing to the discretion of the court, we're limiting that discretion by ordering concurrent sentences on the life offense, or on the life sentences, ordering concurrent life sentences. And then
So on that point, I think this relates to that point. What is your response to the notion that if the court found no error in the convictions and judgment for those other offenses, that there's really no jurisdiction to require resentencing of those offenses?
Your Honor, I think that's incorrect, based on this court's precedent saying that whenever resentencing is required, that it's a de novo proceeding. And so this is where the state's two arguments kind of interlap, in that we have to say, well, what's the default? When there's an error in sentencing, what is the typical correct remedy for that default? And both Seam and Young and this court's other opinions that I've cited from this court that didn't specifically deal with criminal correction of sentencing error, but say that at resentencing, the trial court is operating it's a de novo proceeding, an entirely new resentencing. And with that understanding, I would also just direct the court also to Justice Allen's point, in that in this court's mandate in the last paragraph of Kelliher, it didn't say we're not remanding this case for correction for resentencing. It said, although we would ordinarily leave resentencing to the trial court's sole discretion, here we're limiting that discretion. But even that sentence at the beginning of this court's directions to the trial court implies that resentencing is what was required here. So if in fact resentencing is a de novo proceeding, then the trial court was only operating under the authority that it would have had at a de novo resentencing proceeding, and limited its discretionary authority only by how this court explicitly told the court it was limited. So to that point,
15A1354 also says, it talks about running sentences concurrent or consecutive when they're all part of the same case. They're part of that, and then it also references doing that concurrent or consecutive to other charges, even ones in other jurisdictions.
That's
I
correct.
assume you concede the court would have no authority to change whether those other convictions and sentences in other jurisdictions would go concurrent or consecutive internally. So, in other words, I'm trying to understand, your point is when a resentencing occurs, it's sort of open to take a look at all of the charges that form the basis of convictions, and then one sentencing hearing on resentencing. Is that
so I think based on 1354, the key language is at the same time that we are focusing on here. So because those term of year sentences were imposed at the same time as the life sentences at the original 2004 sentencing proceeding, any of those sentences imposed at the same time are back within the trial court's purview at a resentencing proceeding.
But this paragraph that we're examining doesn't actually say anything about resentencing or when there's a mandate or when there might be specificity to a mandate. It's just talking about what the authority of the court is when multiple sentences are being imposed at the same time. And I guess part of my question following up on Justice Dee's question is, you wouldn't agree that if the person was already subjected to an undischarged term of imprisonment, that a sentencing court could go back and change the sentence for that undischarged term of imprisonment, right?
If I'm understanding your question, Your Honor, are you talking about changing the term of imprisonment, that like the length of the term that was associated with a different crime other than the life crimes?
Right. In other words, this paragraph is saying that a court has the authority to decide whether to run sentences concurrently or consecutively when they're all being imposed together, or when someone is serving time and it is undischarged term of imprisonment, whether that's this jurisdiction or another jurisdiction. And if whatever those sentences might be, the court doesn't have the power to change those sentences, right? All it can do is decide, do the new sentences run concurrently or consecutively? So
1354, you're correct, Your Honor, in that it addresses the imposition of concurrent versus consecutive sentences. Yes, and Your Honor, although it is also true that 15A 1354A does not explicitly mention resentencing, that is where the state then would direct this court to its opinion in Oglesby, which was issued after Kelliher, which clarified that in the Miller resentencing context, 1354A gives a trial court authority at resentencing required by Miller to run term of years sentences either consecutively or concurrently to life sentences that had to be re-examined under Miller. So as this court...
But you would agree that, like, we don't have, because in Oglesby we don't have a situation where the there was sort of what I know this isn't an accurate term in criminal context, but sort of a final judgment on those other charges, and they're out of the case. And I understand like what Justice Earl's question, which is also I think my question to be, is there something about the way the statute is worded? Because of course you couldn't. It seems to me under the statute go back and tinker with the sentences imposed at some other criminal case and say, oh, I'm going to run that sentence consecutive with some other sentence from that proceeding because I want to try to lengthen the sentence now that I'm going to do this one concurrent in the current. You see what I'm saying? And if you can't do that, it seems to me the core question we're trying to figure out is, does something happen in our criminal doctrine that the unappealed convictions and their sentence sort of go out of the case, and in a resentencing you shouldn't tinker with them again? And I haven't seen a case that seems to answer that question.
Your Honor, I don't think there is a case that specifically addresses that question, and that's one of the reasons the state brought this case up on appeal, because I think there is a dearth of state case law addressing this whole, when we're correcting sentencing error, how much authority does the trial court have to revisit that? And as the state pointed out in its briefing, the federal courts have kind of taken two lines of thinking, and on one line, you have the federal courts that say, no, when you remand for correction of sentencing error, we view sentencing very much as this kind of package deal, where if any one aspect of the sentencing calculus is changed, the trial court should have authority to look at the overall package once again to try to best accommodate different sentencing public policy considerations. So things like punishment for the offender, protection of the public, et cetera, and that we should default give the trial court that kind of discretion. The other line of federal cases says no, when a sentencing error has been identified on appeal, it goes back to the trial court. The trial court can only correct the error that was identified on appeal. That's the end. So this court is now in a position where it can kind of weigh those different values and say, well, how do we want to proceed here? If we adopt a de novo resentencing posture, you kind of tend to lean in favor of those interests that say this is, when we disrupt one aspect of defendant's sentence, the trial judge is in the best position to kind of reweigh and recalculate what the new sentence should be in light of that correction. And that's the position the state would ask this court to adopt in this case. I also want to just briefly talk about a defendant raised in oral argument here that the original armed robbery offenses were consolidated, and what the trial court did here at resentencing was to deconsolidate the offenses and then stack the sentences, so to run them consecutively. I'm not sure. That sounds like an argument perhaps under 15A 1335 to say that trial court did not have discretion to choose whether to consolidate or to not consolidate offenses at resentencing. That was never raised in any of defendants' briefing in the Court of Appeals or before this court. The state would point out, although again this issue has not been addressed in briefing, that there is substantial case law in the books in North Carolina that says that trial courts have discretion at resentencing to decide whether or not to consolidate or deconsolidate offenses at resentencing. So just to the extent that was a new argument presented here at oral argument, the state would be happy to present a memorandum of additional authority citing those cases if this court would request that. But just to make you aware of the fact that there is case law, I'm not sure that there is any case law from this court, but there are several opinions from the Court of Appeals that say a trial court has discretion to decide whether to consolidate offenses at resentencing. Another point I just wanted to talk about briefly in front of this court is the question of if this court agrees with the state, what the proper remedy in this case is. So the defendant has asked this court, even if it agrees with the state, to remand the case back to the Court of Appeals to address the remaining issues that the defendant raised before that court. And ordinarily, that would be the appropriate thing to do. I think that is not necessarily required here for a couple of reasons. In the Court of Appeals, the defendant raised issues regarding the law of the case, the proper interpretation of 15A 1354A, and the mandate, the proper interpretation of this court's mandate. And I think that proper resolution before this court of the issues the state has presented kind of inherently involves all of those questions. I don't think you can get to a proper outcome without kind of delving into some way, shape, or form all those kinds of arguments. So if this court were to rule in the state's favor, I don't think that those three issues should be remanded back to the Court of Appeals to address anew. If that's the case, and this court were to agree with me, the only issue remaining then was that defendant raised a constitutional argument saying that even his 36-year sentence received after remand for resentencing was still unconstitutional, despite the fact that his sentence has already been reduced from 50 years before parole eligibility down to 36 years before parole eligibility. He again argued that, well, it's still unconstitutional under the 8th Amendment in Article 1, Section 27. I would just point out to this court that those kinds of constitutional arguments were not raised before the trial court at resentencing and are therefore unpreserved. So again, it's one of these things where normally the state would be in agreement that yes, this case should go back to the Court of Appeals if there are any issues they had not addressed. But here, I think the first three issues the defendant raised are all kind of tied up in the proper resolution of the case before this court. And the only remaining constitutional issue was unpreserved, and therefore under the law of the state should be deemed a waived issue. So for that reason, the state would be asking this court here as the remedy simply to reverse the Court of Appeals decision and to reinstate the original March 31st, 2023 sentencing order. Finally, I would like to address just very briefly the defendant's argument that the state was somehow should not be allowed to raise the argument that is now because it didn't make these arguments in 2018 when defendant was first resentenced as required by Miller. And I think the really important thing there is that this court take note of kind of the unique state of the case law that prosecutors and judges were dealing with in conducting all of these Miller resentencing hearings. So it was a question right from the start, you know, if resentencing is required by Miller, does that implicate only the life sentences for the murder offenses, or does that also implicate these other sentences, term of years sentences for other felonies committed at the same time? And I would point out to the court that in 2018, when the court here was first conducting the Miller resentencing hearing, that both State versus Perry from the Court of Appeals and State versus Lovett from the Court of Appeals were on the books. And at that point in time, they had interpreted, those decisions stood for the proposition that at a Miller resentencing hearing, only the life sentences were on the table. Now in Oglesby, this court stepped in to correct that misunderstanding of the law and said, no, there's actually the statute 1354A that gives the trial court authority at these Miller resentencings to reconsider the term of years sentences. But to the extent that the defendant faults the state for not making these arguments in 2018, I would just point out that the law from the Court of Appeals at that time was inconsistent with then how this court clarified the state of the law in Oglesby. So that's, you know, a rational explanation of why those arguments weren't being made by the state at that point in time. Unless the court has any other questions, I would respectfully ask that you reverse the decision of the Court of Appeals and reinstate the trial court sentencing order from March 31st of 2023. Thank you.
Thank you, counsel. Mr. Clark.
All rise. Yes, oh yes, oh yes. The Supreme Court of North Carolina will be in recess until 9:30 a.m. tomorrow morning. God save the state